We thank you everyone who has joined us today. Thank you for your punctuality and for your patience while we allow others to join the webinar today. Talofa lava and greetings to you all. Thank you for taking the time to attend this webinar presented by the Pacific Islands Law Officers Network Sexual and Gender-Based Violence Working Group. I am the Attorney General of Samoa. My name is Hellene Wallwork. And as many of you know, I am also the chair of this working group, and I'll also be chairing this webinar today. The title of today's webinar is the Special Measures Series, Practical Realities. This is the second webinar in this series, which focuses on the use of special measures in cases involving sexual and gender-based violence. I welcome you all to this webinar series. For those who were unable to join the first webinar, the recording of that is available on PILON's digital library, and this is on the PILON's website for easy access. In our first webinar we held, we heard from two senior prosecutors, one from Fiji and one from Samoa. For many of us, these powerful presentations led to many internal discussions and have prompted a lot of discussions about our role in the legal system and what more we may be able to do to learn how to better support our vulnerable witnesses in these prosecution matters. So today we will hear from the smaller jurisdictions. We'll hear about their experiences to better understand the broader Pacific story. We continue to discuss many barriers to access to justice for victims of sexual and gender-based violence, including in the adversarial legal system, and in particular, through cross-examination in today's presentations. For the benefit of newcomers, I will mention that when we talk about special measures, we are referring to practical tools designed to support witnesses to give their full evidence to the best of their ability. They may relate to how evidence is given, for example, in a closed court via CCTV or through a translator, or even how the courtroom is set up, such as the use of screens and seating arrangements to reduce the stress on the witness or the victim. The PILON Sexual and Gender-Based Violence Working Group has published the model provisions and explanatory text supporting vulnerable witnesses in cases involving sexual and gender-based violence to assist Pacific countries with law reform to implement these measures. Special measures can be implemented in many different ways. I strongly encourage each of you to look at the special measures that are available in your jurisdiction and think about why certain measures are not being used. We are honored to be joined again today by two very experienced practitioners who will share their expertise and the challenges they have faced in implementing special measures. Our first presenter is Cook Islands Deputy Solicitor-General, Annabel Maxwell-Scott, and our second presenter is Republic of Marshall Islands Chief Prosecutor, Cutty Wase. After the presentations, we will pause to see the progress of our graphic recorder, Madison Kitching. Madison will be creating a live visual representation of our speakers' presentations, which will be emailed to you after. I will be keeping to time today because I know you all have busy schedules. After the presentations, I will invite those that can to stay for a question and answer session. We encourage you to ask questions and share positive experiences of using special measures, as well as any challenges you may be facing. So I'm very much looking forward to these presentations today, and I hope you are too. On that note, please let me invite Deputy Solicitor General Annabel Maxwell-Scott to share her presentation with us. Annabel, the floor is yours.
Kia ora, Anna. Good afternoon, everybody from Rarotonga. Please let me know if you can't hear me. Our technology can be a little bit tricky.
We're hearing you very well, Annabel.
Good. All right. So as stated, I'm the Deputy Solicitor General here in the Cook Islands. I've been here for about 18 months and I head up the prosecutions in the Cook Islands. We have had about 5 sessions of judges coming over from New Zealand since I've been here. And we have had about 3 or 4 sexual cases since I have been here. As you know, we are a small country, so we don't get a vast amount of sexual offending or indeed criminal trials. In terms of special measures, there are no legislative measures in place in the Cook Islands. The only provisions we have are for clearing a courtroom and for name suppression. And those are general provisions rather than specifically for sexual cases. We have no specific prosecution guidelines. We have no protocols. Despite that, before 2017, the High Court had ordered the use of screens and the use of support persons in criminal cases. It wasn't until 2017 that evidence in chief was given via a video link. To be fair, there had been a gap in prosecutions of child sexual offences, but that was the first time that the technology was used. So, bearing in mind we don't have specific provisions, how do we get around that? The Evidence Act in the Cook Islands is silent as to alternative modes of evidence. It was passed in 1968, so that probably explains why. Section 3 of that act does give the courts very wide discretion to admit evidence, saying that the court may, in proceedings, admit and receive such evidence as it sees fit and accept and act on such evidence as it thinks sufficient. So I think I was just saying that we use various means of trying to get special measures used in the court here. So going to the Judicature Act, that gives the court a wide discretion to determine its own practice and procedures. And that's used in the civil and the criminal jurisdiction, basically where there's a gap or where things have developed in other places and basically the law hasn't caught up yet. So the judges use that on a regular basis. We have in the criminal jurisdiction, the Criminal Procedure Act at Section 3 that allows us to directly import New Zealand law where there is a gap. We regularly call that the importation provision. And that allows us to use any New Zealand criminal procedure where it does not conflict or be inconsistent with Cook Islands law. So as you can imagine, that's a pretty useful section for us. And we regularly use it, not just for special measures, but for other areas that don't have law, such as propensity, lots of them. So that's a very useful provision. Obviously, this isn't the ideal scenario, but the provisions in the Judicature Act, the Evidence Act, and the Criminal Procedure Act give the court a broad discretion to exercise its discretion to ensure that the best evidence is available. And that's what we want. We don't really mind how we get there, as long as we get there. Since the Criminal Procedure Act and other pieces of legislation were passed here some time ago, there has been, of course, significant technological advances and attitudes and progress in trial procedures. And due to a lack of resources, if not appetite for legal reform, that progress has not been reflected in Cook Islands law. I hope that changes soon, and certainly this forum that we're in now and the cohesion that we're getting across the nations, I hope will assist with that. Since 2017, video links have been used a number of times and are now accepted as usual in child sexual cases. That said, well, certainly when I arrived here a year and a half ago, there was no video camera. The police had gone back to using paper interviews because the equipment wasn't working and there was no resources to buy a new camera. We got a new camera last year, or sometime last year, so they are starting again, but we had a gap of about a year, which, as you can imagine, was extremely frustrating and led certainly to a trial I did a few weeks ago to a 14-year-old having to give evidence, go through her evidence in the courtroom because I didn't have a video recording and because it had taken place over a number of months and because of the technology here, doing via video link was just not going to work. So we did have to get her into the courtroom for a day because of that lack of a recording. But hopefully that won't occur again. So the judges allow it to be used, and I haven't yet seen a defense lawyer object to it. That said, I have seen objections to the use of it beyond a child sex trial. A vulnerable witness, an older lady who was scared, that was opposed by the defence. However, there's no ruling on the system, so it may well be that it resolved. I don't know. But there will be other arguments to extend the use of video equipment. New Zealand legislation allows for it to be used in wide circumstances. I'm not going to go over New Zealand legislation, but obviously there's a number of types of cases where witnesses are vulnerable and best evidence warrants the use of special measures. And that will go beyond just violent and sexual offending. For example, we're seeing increasing use or provision of assistance by the co-accused here. That used to be very rare, but now possibly due to larger scale drug offending, we are seeing more people cooperate with the police. That said, we do have problems. In a recent rape trial a few weeks ago, after the trial, so this is linked but not quite the same as special measures, but after the trial, it was asked that the victim be allowed to read out her victim impact statement. We have a Victim Act from 1999 that allows for victim impact statements. However, that act says that they must be either in writing or read out by the prosecutor. Despite the fact that previous judges had allowed a victim to read out their own impact statement on the basis that the spirit and the aim of the legislation was obviously to allow for the rights of the victim and for them to be heard. In the recent case, the Chief Justice ruled that Parliament had specifically considered the reading of victim impact statements and must have decided that only the prosecutor could do it. He inferred that Parliament must have considered specifically whether to allow a victim to do so and rejected such a measure. I haven't checked Hansard or the policy from back then, but I imagine it's pretty unlikely that debate occurred back in 1999. We now know it's commonplace in New Zealand, UK, US, many jurisdictions for a victim to be allowed to read out their impact statement in court and for them to be heard. This also needs legislating on, as do all aspects of special measures. I note that in this case, the defence objected to the victim reading out her statement, and that was on the rather bizarre basis that it was giving her a second bite at the cherry. That slightly backfired for the defence lawyer, as what happened is this was widely reported in local and social media. In fact, it was headline news that this victim had not been allowed to read out her impact statement, and the defence had objected. What then happened is I read out the victim's statement in full. It was 4 pages long. And with the victim's consent, it was published an entire page from the Saturday newspaper. Page 3 was just her victim impact statement with contact details at the bottom for those in help. So progress. Progress comes in different forms. And in that instance, although we lost the battle, I'd say we won the war. And we got a high profile for sex offending and what occurs in trials, and a huge amount of public awareness from what occurred there. So we do our best to work with what we've got. We do try to follow the leads of other jurisdictions and the ever-increasing awareness of the need to consider all aspects of the court process for witnesses, especially vulnerable witnesses, which is in the interest of justice. Does this extend to the control of cross-examination? Well, we rely on judicial control of admissibility and relevance matters. We rely on the judge to control the cross-examination and try to prevent re-victimization and portrayal of rape myths. Unfortunately, rape myths are alive and kicking here, and currently all the jury trials are conducted by one defense lawyer. He continues to bully, ask inappropriate and inadmissible questions. So by the time you stand up, it is too late. And he then continues to rely on and cross-examine on rape myths, i.e., you didn't cry, you didn't scream, you would be injured if this had happened, you didn't run away, you didn't tell an adult, etc., therefore you are lying over and over again. Some judges control him better than others, but generally he's pretty hard to stop. And I really hope that he acts in a manner very rare in the legal profession in 2022. We do object, we do try to control him, but legislation, or at the very least protocols, would assist. We call counterintuitive evidence and DSEC evidence. That, of course, assists our case and assists the prosecution, but it does not help the complainant who has had to sit through the trial process and giving her evidence already. I have a trial starting in 4 weeks with the complainants at age 7 to 12. We have in previous times asked for his questions to be vetted by the court, and we are likely to do that on this particular occasion. But this is reliant on having the right judge because they vary very much in the control that they will give. We need better control and better guidance for the profession. I would like to say we also need training for the profession, but the problem we have at the moment is we have one older defence lawyer, and that's not going to work with him. But that is a specific problem we have in the Cook Islands, and we are trying to do our best to see how that can be addressed. I'd be very keen to hear from other jurisdictions as to the controls in place that you have for cross-examination, whilst of course allowing for fair trial rights to be maintained. And I'd like to know what is done to ensure that victims are not re-traumatized and juries are not misled by counsel, as it seems to me it varies a lot from court to court, from jurisdiction to jurisdiction. So I'd be very interested to hear what other countries are doing. We also have a mechanism to ensure that somebody is not cross-examined by somebody who's self-represented. And again, we import New Zealand law for that, and the judge can control those questions. What we do have in our legislation is closed courtroom provisions, and that's the power for the court to clear the court and forbid reporting of the proceedings. The test is quite an old test. It's if it's in the interest of justice or of public morality or of the reputation of any victim of any alleged sexual offence or offence of extortion. So I think quite an old piece of legislation, but we still use it. That said, last year, one judge did refuse to clear the courtroom for a sexual case where the child was giving evidence from New Zealand. I think he seemed to think because she was not physically in the courtroom, he didn't need to clear the court. I don't really understand why he did that, but there we go. So we're not without our problems. We also have name suppression provisions, and that again gives the court a wide discretion to order suppression of names and identifying details. And of course, as you can imagine, in a small nation like this, identifying details can be very wide. It can be as simple as where someone goes to school. So we have to be very careful about that. And we work well with the press here to ensure that people aren't identified. So in terms of other cases beyond child sexual offending, the use of special measures simply hasn't occurred yet here. At the lower level, domestic violence prosecutions, these are dealt with by the police. I do liaise with them and speak to them, and I understand there's never even been a conversation about special measures, and that is a problem, and we need to start one. We need education as to the need and impact of special measures on the successful prosecution of offences and the battle against crime. We are a very long way here from other measures such as the use of intermediaries or communication assistance. But we have to start somewhere, and this seems to be as good a place as any. So I thank you all for your support, and we look forward to hearing from other jurisdictions as to their experiences.
Thank you very much, Ms. Maxwell-Scott, for that fantastic presentation. I was particularly interested to hear about your plans to increase the use of special measures. I was also interested to hear your comment about how to control cross-examination fully by asking the judge to vet the questions beforehand. That's certainly something we haven't yet had here in Samoa, but we'll be interested to hear more about it from yourself and our colleagues in the Pacific if that has been done. So we will now hear from Chief Prosecutor Cutty Wase on the use of special measures in the Republic of Marshall Islands. Thank you, Cutty. The floor is yours.
Greetings of Yokwe from RMI. It's an honor to speak on behalf of RMI with respect to special measures, our experience here. And thank you, PILON, for this opportunity, great opportunity. Before I begin, for the records, as you already know, my name is Cutty Wase, and that's how I pronounce my name, Cutty Wase. So what are some of the what are special measures from RMI's perspective? Special measures, these are courts criminal procedures designed for special people with special conditions and also for special circumstances. But I like how the court put it in its 2020 annual reports. It reads, and I will quote, to ensure public's access to justice. That was 2000 before the COVID-19, 2019. That was but then after March 2020, it includes the word without undue disruption and without compromising their health and safety. Now, our courts here have discretion to promulgate all procedural regulations. That is under the Constitution, RMI Constitution, Article 6, Section 1, Subsection 2. I think that we, officers of the court, we also have a significant role in development of these important special measures. Special measures is not a popular word we use here in RMI, but we understand the importance of it. It's already in the law. I mean, it's not in the law, but we have it in our court's criminal procedures. They're designed for, special measures are designed for vulnerable and intimidated victims, witnesses, to ensure they have access to justice. And as I've stated earlier, because of COVID-19, RMI courts has amended its rules by allowing the use of audio conferences and video links to conduct criminal proceedings and to take testimony of children and including mentally defective persons. That is something new that was just added to our criminal procedures. Now I will talk about the two major criminal cases that we applied special measures. The first one was back in 2017. It's a sexual assault case on a victim, a 19-year-old female who was mentally defective. The defendant, a trusted friend of the victim's family. Unfortunately, in this case, the sole witness is the victim herself. She was the only eyewitness. In the end, the defendant was convicted and was sentenced to 12 years imprisonment. It was a case, this case that led to the incorporation of the additional alternative methods for mentally defective person. And I personally was the one who handled this case and prosecuted. It was unfortunate for me at the time because our criminal procedure rules didn't provide for avenue or measures for mentally defective people. So even though I applied for alternative methods, court denied given the absence of these measures. But during trial, I personally asked the court if I could use some other measures, and the court did allow me. So I asked for court if I could have the presence of the most trusted person to the victim, her older sister. So court allowed me to do that. And she actually was present in the court throughout the examinations. And I also asked court if I could use some certain language, including body language, because remember, this is a mentally defective person or person with disability who, even though she was an adult, she has a mental age of a 4-year-old child. So I asked court if I could use leading questions, and if she could, if the sister could help me explain these questions to the victim, the witness. All of these measures were approved because the defense lawyer did not object. After like I said, after the trial, the defendant was convicted and sentenced to 12 years imprisonment. The other case that I want to share with you is it's a recent case in this year. It's named RMI versus Lanez Muller. It's also a sexual assault case, but this time is involved a minor child, 10-year-old girl. In this case, the defendant is the father of this victim, a mother's boyfriend, also a trusted person to the victim. In this case, in particular, the former AG made a pre-trial motion for alternative methods to have the girl disposed and also to be recorded by video. And after the deposition, the AG Republic filed to be admitted into evidence. And again, the defense lawyer did not object. And so it was luckily admitted and was presented during trial and become admitted into evidence as well. So these are the two cases that major case that we applied or employed special measures to help our victims who were not the only eyewitness, but were with special conditions and couldn't do it by themselves. One thing I also want to raise in the RMI versus Antola case that I personally handled, I remember, given that the rule of procedure didn't provide that avenue for mentally defective persons, the court asked me, what ground do you have? What's your basis for requesting the admission of a mentally defective person when the avenue is not? And I argued and I asked court that it's going back to the court's the principle of justice, value of constitutional mandates of the court is to allow and to ensure public access to justice. So that was that was the argument that I was able to put it forward, and the for court's basis for court to granted that motion, even though it was orally made during the trial. So these are the two cases that major cases that we were able to use, or we used special measures. Now, talking about the challenges that we have, including and even generally in all the cases, sexual and gender-based violence crimes, the cases that we have handled. One issue that we often come up faced with is the conflict of interest by relations and professions. You know, being small country, you know, almost everybody knows everybody here. It can be the judge being related to the victim, or the prosecutors to the victim or the defendant, and also by professions. It makes it difficult for us to move forward with our cases. And another challenge is lack of psychiatrists. Currently, we only have one specialized psychiatrist here on island. And because of that reason, sometimes we won't be able to use him or get him to help us to, you know, to work with our victims to extract those the evidence that are very crucial to, you know, to prove the elements of the crime. And because of that, we really cannot effectively prosecute our case. And there are other cases where the defendant himself has already engaged our only psychiatrist. And so if we have more psychiatrists, we have more, we have someone who can help us. There are also certain cases where even in domestic violence cases, defendants engage the psychiatrist, and we really can do much about it because we don't have extra or additional to do. And also for second opinions, we won't be able to do that with only one. But that's also conflict of interest. Moving on, I also want to share it today that our laws here don't mention that. I've searched all of our laws, including our Evidence Act, the criminal codes. I couldn't find the word special measures. So it's very unfortunate, and that is something that we really need to work on to ensure that public there is access to public justice. Sorry. So far, only court has the discretion, but given the defendant's constitutional rights as well, we're putting court in a hot spot situation where it needs to balance both rights. One right that is not specific and it's not present, it's not there in the law, and the other one, which is already there in our constitution, just like the dependent constitutional rights, the confrontation clause. Sorry, it's specific. It's written and enshrined in our constitution. And special measure, yet we don't have it in our legislation. The other one, last one, is that's to do with the Constitution as well, our challenge. And this is in Article 2 in our Bill of Rights, Section 4, subsection 7. And I would like to read it to you so you can understand what I mean by why is it a challenge to us prosecutors in RMI. It states, no person shall be compelled in any criminal cases to be a witness against himself or against his spouse, parents, child, or sibling, or to keep testimonial evidence against any such person whenever that evidence might directly or indirectly be used to obtain such person's criminal convictions. So I hope you understand what, so basically, because most of these crimes, especially sexual and gender-based violence cases, happens in a privacy house, hidden place, where away from the public. So it's very hard. Usually, hardly eyewitness, independent eyewitness. Most of the time, we get witnesses, but they are related, very close relative of the defendant, which is they're not compelled to be a witness under the Constitution. That's a huge challenge for us here. So that is something that we need to change in when we have our next constitutional convention. Okay, I think I've come to that's the end of my presentation on RMI perspective. I'm sorry if I've, but I'm ready to answer any questions.
Thank you very much, Chief Prosecutor Wase. That was such an interesting and informative presentation. I really appreciated how you explained the meaning of special measures, or rather the lack of it in RMI, and particularly the two case studies that you shared with us, and how you worked around the system to ensure that you were able to use some alternative measures to assist your victim witness, and that especially in the case that you personally handled in 2017. So that's our graphic recording right there. Isn't that looking great, everyone? Thank you very much, Madison. We all really enjoy having this engaging record of our webinars.
No worries at all. Thank you very much for having me.
No, thank you. So that actually concludes the formal presentations today, and I now invite you to stay connected for a short question and answer session. And it's at this point that I invite any interested participants to raise their hand or post a question in our little chat section right there about any of the issues raised by our speakers today. And if I could just remind our audience members to remain on mute unless you're asking a question. While we're waiting for questions to come up, can I just go back to the question I'd asked earlier from our first presentation? And Annabel, you talked about, particularly interested in, you talked about how you could use measures to control cross-examination of victims by asking for the questions to be vetted beforehand. That's a fair concept from our perspective here in Samoa. Can you just elaborate on how you go about that, please?
Well, it asks the defense lawyer to write down a list of either specific topics or specific questions. It's commonly employed in New Zealand. There's been two courts in New Zealand that have employed a sexual violence pilot. It depends a little bit from judge to judge. Some literally ask you to write down the questions, and some are a little bit better and kind of give you a sort of wider range to go through different topics. but it's really to ensure, especially where a child is very young or particularly vulnerable, or a witness particularly vulnerable, that they don't get asked questions they don't understand. They don't go into inadmissible areas so that the trial has to be aborted, and that the judge just checks that the questions and the language used is appropriate. It is quite interventionist. From somebody who's more often a defense lawyer, I do have some reservations about it. And reality is, if you're a good lawyer, it shouldn't have to be done. But I think it was mainly put in place because there was a lot of bullying going on. There was a lot of re-traumatizing, a lot of myths being portrayed, a lot of use of inappropriate language, especially for children. And you know, a lot of barristers just simply aren't trained in cross-examining vulnerable witnesses and children. Whether they should be trained and whether there should be restrictions on which barristers can do which type of work is a different issue. And I know that's something that's considered in other jurisdictions. But we have done it here, and just asking for this lawyer for the list of areas he was going to go into. For example, in the last trial I did against him, we knew from something that he'd submitted that he was going to ask questions about the complainant's veracity. I also had an inkling that he may go down the sexual history path. So I basically put that out there to the court in a pre-trial memo and just said, just to make these clear, these areas are not admissible. So although it wasn't a specific, can you write down your questions, I made sure that the judge clarified with the lawyer that he wasn't going to do this. As it happened, he did do the veracity one, and it was too late by the time he stood up and did it. Not that she answered, but the question was out there. So it really is that it's kind of a preemptive method of controlling and assuring that there isn't an aborted trial and that the witness isn't unnecessarily harassed.
Thank you, Annabel. That is very interesting, and I think can be used very well and can be helpful in these cases. We'll have to explore that a bit further here in our own jurisdiction. But it's interesting that it's pretty much judge-led rather than from the legislative side. That's
yes, it is. I don't know if that's the same in the UK. I left the UK quite a long time ago, but it is protocol-led. Rather than in the legislation, although of course the legislation does allow for the judge to ensure that the questions are appropriate and not inadmissible. So it's kind of an extension of that, but by a much more interventionist route.
Thank you for that explanation. Very clear. Are there any other questions from anyone before we move on?
Chair, there is a question that came through in the chat, which I'll just read out. It's to Chief Prosecutor Wase, and it's, what strategies do you use to manage a conflict of interest between the defendant and either a judge or prosecutor?
Thank you for that question. It's a very, probably a very common theme in the small communities that we practice in. Chief Prosecutor Wase, do you want to address that question?
Yes. Thank you for the questions. I don't know what exactly what answer you're expecting from me, but usually when we have a conflict of interest, the first thing would do is to declare that if I am conflicted by way of relationship, related to perhaps the defendant or the defendant, I will have to excuse myself and transfer the case to the next prosecutor. We have 3 so far, one foreigner and one local, or 3 of us all together here. Thank you.
Thank you, Chief Prosecutor Wase.
I'll just read out another question that we have come through the chat. This one wasn't addressed to a particular presenter, but it's, have you seen a shift in judicial attitudes towards special measures?
Well, it sounds like in the RMI at least, the COVID experience has brought about a shift by allowing special measures to be used in terms of video links and audio-visual recordings for witnesses to give evidence, which is a silver lining in the era that we're living in right now from the COVID times.
Maybe I'll go first. If that's okay. Yes, we have seen some adjustment to the judicial attitude towards special measures. First of all, as I've said earlier, it's not a popular word. It's not in our criminal procedures, but we do have some other measures, just like alternative methods. That is one, allowing the child just for the child. And before the COVID 2019, the court, like I said, didn't allow me to apply, grant my motion to allow an adult witness victim to use the special methods, alternative methods, because the reason being is it's not provided under the criminal procedure. But after the COVID, after that case, I think the court started to realize that there's a need for special people to, to provide, to also to keep their best evidence, and only court can allow that. So from that case, court amends its rule from that case. It's a precedent. They amend their rule to include also alternative methods for mentally defective person. Before it was just for child witness. Now they include mentally defective person, but just the two. We need to add more, and we have a role here. And also with the COVID-19, government has changed its law, relaxed some of this law, and keep that power also for court, and court that make it very specific that in case COVID is here, we have positive case, automatic, they will allow through video conference, child, mentally defective, and any other witness that will need the special measures. Thank you.
Thank you very much for that explanation, Chief Prosecutor Wase. Well, I think that concludes our questions from our audience today. Thank you very much, everyone, for taking the time to put those questions up. And that brings us to the end of our webinar today, PILON members and friends. I regret to have to end things here, but I'm sure both of our speakers today would be happy for you to contact them directly if you have any further questions for them. I hope the presentations have inspired you to think about the special measures that are available in your jurisdictions and how to make better use of them. For any of your colleagues that couldn't make it today, a recording of this webinar will be circulated to all attendees, along with the finalized posters from our graphic recorder, Madison. We will continue these important discussions at the next webinar in this series. In the meantime, I encourage you all to look for opportunities to collaborate with your colleagues across the region on these topics. We would love to hear your ideas and suggestions about better ways of working together. So we will be sending out a very short survey after the webinar. Would be really grateful if you could use it to provide feedback. I'd like to thank our presenters today. Thank you very much to Deputy Solicitor-General Annabel Maxwell-Scott. Thank you very much to Chief Prosecutor Cutty Wase for your presentations. Thank you to our supporters today from the Australian Attorney General's Office. It is much appreciated. If any of you would like information or assistance with the implementation of special measures in your country, please provide your contact details in the survey. These requests may be considered by the Australian Attorney General's Department. Alternatively, you can email the PILON Secretariat and we will ensure you get the information you need. I wish to thank everyone again today for your attendance today and wish everyone a happy and safe afternoon and weekend ahead. We look forward to seeing you at the next webinar. Thank you and tō whāsoi.